scrutinize intra-party elections and declare them void, and further to deny the electoral symbol, common electoral symbol, to a political party on the basis of any alleged irregularities in the intra-party elections. That is my point number one I'll be arguing on. Point number two, Your Lordship, is that under Article 17(2) of the Constitution, the right to form political parties is guaranteed, and over the years the Supreme Court has robustly interpreted Article 17(2) to not just forming but also operating as a political party. Contesting elections with a unified symbol falls squarely within this right. And denying an electoral symbol.
Just slow down. Contesting elections with a unified symbol falls squarely. Unified symbol falls with a unified symbol falls squarely within this right. Denying an electoral symbol.
The third point or the
same one? Just ending, closing it now.
This right.
G. Denying an electoral symbol based on alleged irregularities in intra-party elections is a violation of Article 17(2) and an unreasonable restriction, and hence void. The third ground, Your Lordship, connected with this is that the interpretation of the provisions of the Election Act proposed by the ECP would amount to a violation of Article 17(2) and hence is incorrect. My third point is, Your Lordship, fourth one, that the Constitution states that
The Election Commission is not a court of law.